Right now we're going to go to Lori from Knoxville. Hi, Lori.
Hey.
Hey,
How
Lori.
are you?
Last year I was in a little fender bender. I was at fault. I had no problem with it. I turned it over to my insurance company. I got a call a few months later. The passenger in the car was going to claim medical. And I was just flabbergasted because there was no way anybody was hurt in that little fender bender. Then a few months later, I hadn't heard anything, so I called my insurance, and they said that the complainant had dropped the claim. How long do I have the statute on that?
The statute of limitations, Lori, on a personal injury claim is 2 years from the date of the accident, which means that they either have to settle that claim with your insurance company or file a lawsuit against you within 2 years. Now, there are some factual scenarios where that time can be extended, but the general rule is that it's going to be 2 years from the date of the accident. So if you said it was last year, is that correct?
Right.
Okay, well, if you get to the 2-year anniversary and you haven't heard anything, then you don't have to worry about them bringing a claim against you. But, you know, if they do file a lawsuit against you, your insurance company will provide you with an attorney for your defense and things like that. So that's why you have insurance, to protect you and your assets when you are at fault in an accident, even one that's relatively minor. So.
Right.
But if they've dropped the claim, you may not hear anything else about it. But if you can get to that 2-year point and they have not brought a lawsuit against you or settled with your insurance company, then that claim will have expired.
Oh, okay.
Yeah. The insurance company is supposed to act in her best interest, or at least put her interest equal with their own. Historically, they don't do that.
Right.
So minor injuries such as Lori's talking about, oftentimes some insurance companies will just take a hard stand, say we're not going to pay anything. We're going to adopt her position that the person wasn't hurt. So Lori's going to find herself sued, getting written discovery, have to give a deposition, have to explain a bunch of personal business, go to trial, all because her insurance company's not being reasonable.
When she would probably just rather resolve the claim, you know. So a lot of times, if you are at fault in an accident, it's a good idea to talk to an attorney who's looking out for your interest and maybe is not concerned with the interest of your insurance company.
Yeah. That way, if the other side makes a demand to settle the case, your attorney can say pay it, and that puts additional pressure on the insurance company to get it over with.
Gotcha.
So you don't mess with it.
Okay.
Opinions expressed on Law Call are those of the participants and do not necessarily reflect the opinions of 13 WMAZ staff or management, nor any legal or judicial entity. The legal information supplied in this broadcast is general information only and is not intended to be legal advice for any given situation. Do not rely on broadcast information without consulting an attorney. Contingent attorney's fees refers only to those fees charged by the attorneys for legal services. Such fees are not permitted in all types of cases. Court costs and other additional expenses of legal action usually must be paid by